Hi there, folks. Welcome to Sumit Academy. This is my fourth video on AFSPA. I shall now deal with the criticism of AFSPA, especially by the human rights organizations. The debate on discontinuing with the Armed Forces Special Powers Act, diluting it, or applying it selectively within a state appears to be unending. Every now and then the subject comes alive, either when a case of a fake encounter is brought forward or human rights activists revisit the act and call it draconian or worse. At other times, it is imputed that the army has vested interest in its continuance, even when insurgency is on the decline. So let's have a look at the major critical points of these human rights groups. The first criticism is that the provisions of the Act are inherently flawed. The immunity provided by the law against any prosecution, except by central government permission, is manifested in cruelty and violation of human rights. Now, there have been many cases of rape and torture by the army personnel, that is what they are alleging, but none has been prosecuted so far. That is the first allegation. The second one, the grounds of declaration of a disturbed area have not been defined in the Act. Moreover, once an area has been declared disturbed, it cannot be subjected to judicial review. Critics say that the law does not provide adequate safeguards in application of AFSPA. The third one, the power to shoot to the extent of causing death and search without warrant are in contravention of Article 21 of the Constitution, the right to life, which forms the foundation of all other fundamental rights. Number 4. The law overrides the Criminal Procedure Code, which lays down a proper procedure for police personnel in dealing with law and order problems. There are no adequate safeguards in the implementation of AFSPA. Even the Supreme Court has stressed the need for following the appropriate procedure, especially when security forces work in the aid of civil authorities. The fifth criticism, the Act has not been able to contain insurgency and maintain law and order in the disturbed regions. When it was imposed in the Northeast, there were few insurgent groups, but today there are more than 24 groups operating in the region. In addition to this, there has been a rise in the number of civilians killed by the forces. Number 6. Grave human rights violations have actually helped the insurgents to mobilize the people against the government. AFSPA has further intensified the demand for autonomy by the people, leading to increase in agitations. This gives rise to a vicious circle of continuing the law for an indefinite period. Right, so these were the allegations. Let us now try to analyze these criticisms, these allegations, and answer them to the best of our ability so that we give a complete look to our answer. Now, first of all, is it truly a draconian law? Now, many have called AFSPA a draconian law and have vehemently supported its repeal. But most lack even a rudimentary, let alone in-depth knowledge on the subject. Now, this act has been in force for almost 60 years now, only because it was essential for the conduct of smooth counterinsurgency operations by the army. It will continue to be needed as long as the army is to be employed on counterinsurgency or terrorism tasks. And why? Because without it, the central government, as per the Constitution of India, cannot deploy the armed forces on internal security duties. So you see, it is a administrative measure of the central government to employ the army inside the country. Now, this act cannot be linked to the Criminal Procedure Code because the very nature and dimensions of violence that prevails during peak periods of insurgency and the methods and means required to combat these are far different from normal everyday crime. Insurgency in its virulent form totally paralyzes the administration and results in collapse of the law and order machinery in the affected areas. Now, when such a state is reached, first the Disturbed Area Act is promulgated and then only AFSPA brought in and the army is deployed. You see, the activists are merely displaying their confusion in this argument that such a situation can be handled as a normal law and order problem. Whereas where the army may be called on to assist the civil administration and principle of the use of minimum force may be made to apply. Besides hideouts and other logistical bases, the terror groups have a significant number of sleeper cells, sympathizers, or spies who provide information on targets for their next attack. Now, we have seen that the police in these states are ill-equipped to tackle these elements. And moreover, in many cases, it has been observed that they are sympathizers within the police ranks. These factors hinder counter-terrorist operations. If the army is required to fight the menace of terrorism, then they must be given some legal cover to investigate, apprehend, interrogate, and act against potential suspects or in specific areas. Now, the police already has these powers, but as per the Constitution, the army does not. So, the army must be given some sort of legal cover. Another problem for the implementation of AFSPA in these areas is the reluctance of the local police to act even if they want to fight the terrorists. Now, this was observed in Punjab during the insurgency days when the families of police officers were targeted by the terrorists to avenge any operation. Since the police officers are local to the area, it makes them an easy target for terrorist backlash. Now, with the army undertaking an operation, the chances of a backlash is grossly minimized. In all of this, there are some important facts which we must remember at all times. The first one, though our constitution is federal in structure and we propagate peaceful coexistence, it has not eliminated unrest, hatred, violence, and threat to the sovereignty and integrity of the country. Point 2. It is the duty of the Union to protect every state against external aggression and internal disturbance, and to ensure that the government of every state is carried on in accordance with the provisions of the Constitution of India. Number 3. Having regard to the pluralistic nature of Indian polity, that is, multiplicity of religions and languages, ethnic divisions, and lack of accommodation in political thoughts, economic disparities and geographical imbalances may at times give rise to unresolved aspirations. Number 4. The state may also fail to bring about peaceful and orderly settlement amongst the society. Failure of the state administration to maintain law and order may develop into a situation known as disturbed and dangerous, where the police and other available agencies may not be able to control the extraordinary situation. Number 5. The ultimate force available with the Union of India is its armed forces. Hence, deployment of the armed forces is the final choice. Number 6. The courts have ruled time and again that the Act is not a colorable legislation or fraud on the Constitution. They have also held that powers under sections 4 and 5 of the Act are not arbitrary and unreasonable. Mistakes can take place due to the very nature of the operations, but deliberate acts of excesses or fake encounters must never be condoned by any government. The armed forces on its own has acted in innumerable cases against such offenders, and scores of personnel have been court-martialed and sent to prison or cashiered, and that includes a number of officers. So what I am trying to do is that I have tried to counter all the critical points which the human rights group have brought out and presented it to you to give you a complete picture. Now my final point in this video is, are the police under AFSPA? You see, the police do not come under AFSPA since they already have powers to maintain law and order. There are enough acts that give it the powers to deal with any law and order situation. Now this confusion shows up every time somebody blames AFSPA for police perpetrated atrocities. Even when the army is available under AFSPA, the police carry on their normal law and order duties. Well, that's it from me on this, the fourth of my videos on AFSPA. Do look out for all my videos on AFSPA so that you get a complete picture for your examination. I do hope that the points I have given you are more than enough to build your 250 to 350 word answer. Remember, the UPSC examiners are pretty strict about the word limit. So always and always read the instructions on the number of words before you start writing your answer. Till then, as we always do, stay cheerful and do remember to like and subscribe to my channel so that you do not miss out on my future videos. In case you have any doubts or you want additional videos or you want additional subjects, do remember to drop me a line at sumitacademy20@gmail.com or do drop me a comment below this video. Cheers.